working for you. This is Fox 2 News Morning.
Well, for more than 25 years, attorney David Femminineo has passionately pursued compensation for victims of auto, truck, and motorcycle accidents. But slips and falls, not so much. And that's because the law favored businesses. But now a new Supreme Court decision has helped victims of slips and falls in this state. Joining us now via Skype, attorney David Femminineo. Always good to see you, David. I hope things are treating you well.
Things are great. Thank you for allowing me to be on, Charlie. I'm happy to be here.
All right, let me give you a hypothetical, okay? I'm going to get some groceries of a well-known department store, supermarket, okay? I get out of my car, I'm walking in. The parking lot is a disaster. Chunks of concrete, broken. I slip, I fall, I break my back. Before this new case, is there a case? Do I have a case? Can I sue?
For the last 23 years, there was a case that dominated our jurisprudence in Michigan for premises liability called Lugo versus Ameritech. That case stood for the proposition that if you trip, slip, or fall for whatever reason due to some defect in the roadway, the sidewalk, or the parking lot, if you were able to look back and say, geez, what caused me to fall? If you were able to look back and see that you fell as a result of broken concrete, the case called Lugo versus Ameritech for the last 23 years said you will not make it but to a jury. Your case will be dismissed by what's known as the open and obvious doctrine. That doctrine stood for the proposition that if you could see it after you fall on it, then you cannot recover. The Michigan Supreme Court has changed that ruling. That case called Lugo versus Ameritech has been overruled, and now the Michigan Supreme Court has swung the courthouse doors open to individuals who've been injured in accidents. There is now a new standard, Charlie.
Right.
The new standard is comparative negligence.
David, hold on. He's getting very excited for this new case, I have a feeling. Because for 23 years, for the most part, lawyers could not successfully bring a slip and fall case, despite the fact that the premises where you slipped was a disaster. Broken concrete, ice that was not salted, all kinds of problems. No case. Now that's changed, though, with this new case that came out just a couple of days ago. So what did the Supreme Court say you could do now?
The Supreme Court said that the standard was wrong that we've been under for the last 23, 24 years. The new standard is comparative fault. The Michigan Supreme Court essentially said we're going to allow these cases to get to a jury, but then it will be up to a jury, the trier of fact, to determine whether or not the landowner who allowed the defective condition of the parking lot to exist or the person who fell, who's at fault? And in Michigan, it's called comparative fault. And the trier of fact will have to balance between, is it the fault of the landowner or is it the fault of the person who wasn't watching where they were walking? But we can now get to a jury on these cases, which is a big advantage now.
Seems to me that lawyers like you are gonna you're gonna open up an entire new wing at the Femminineo law firm on these slips and falls. This is a win for lawyers more so than business people, isn't it really?
No, it's a win for injured persons who have been injured in accidents, and they deserve compensation. The courthouse doors for the last 21 years have been slammed in their faces, and their cases have been dismissed. Now the courthouse doors are open, and their cases can be heard. So if you were injured in the last 3 years in an accident, you may now be able to recover, even though lawyers probably told you previously you don't have a case. You may now have a case.
All right, but so what about let's put your other hat on, the businesses. If I'm a business and listen, I'm struggling restaurant. You know, I can barely get workers here, and now my parking lot's a little bit, maybe 2 or 3 inches bad. Are you telling me now that I could be sued and who knows, maybe go out of business? I don't even know if my insurance is going to cover this.
reputable businesses have insurance, and it's been the insurance companies who have stuck all that money in their pocket and never had to bring it out to pay people who have been injured on business premises. That is simply the fact. Now the insurance companies will actually have to pay for their liability of business owners. So yes, but for the better good of all, business owners will have to make sure that their premises are kept in a reasonable state of repair.
You think juries always get it right, though? I mean, you're saying basically now it's going to be up to a jury to decide, was me walking in the bad parking lot the fault, or was it the landowner who should have cleaned the parking lot? I mean, isn't it really, I mean, is it fair that a jury makes a decision, really?
Well, it's a heck of a lot better than being thrown out of court. I would take a jury trial over being thrown out of court any day of the week. And with me, I'll convince that jury that it is, in fact, the fault of the business owner and not the fault of my client. We have to keep those premises in a reasonable shape. And if they fail to do it, they're liable and make the insurance company pay.
Last question, okay, because we got to run here. But when you heard about this new decision that now you can sue if you had a slip and fall, for the most part, did you guys throw a party?
No, we did not throw a party, but we're happy for our clients that they can actually access the courts now here in Michigan.
All right. It's gonna be a case that we're gonna hear a lot about. It does change the law after 20-plus years here in the state of Michigan. David Femminineo, always good to see you. Love your commercials. Say hi to everybody in Mount Clemens, and we'll talk soon. All right?
Thanks, Charlie. Good to see you.
I appreciate it.